Good afternoon, everybody. My name is Caitlin Atlas, and I am here today with my colleagues Kristen Kinnist and Brittany Begley, and we are pleased to welcome you to the first webinar of the 2024-2025 school year. We are here today to talk about some legal updates on special education student placement. Today, we're going to start with talking about some updates on placement relative to special education cooperatives and other placements, some changes in the statutory language of the school code in Article 14. And then we're going to move on to the Illinois State Board of Education's new guidance document on placement changes for special education students. So we are really thrilled to see so many special education directors with us on the Zoom call and some representatives from the Illinois State Board of Education. We are live on Zoom for those of you who are joining us live today. Please feel free to use the chat feature or the Q&A feature on Zoom. We will be monitoring that throughout today's webinar. You're free to ask questions, share comments. Just please do remember we are on Zoom with a live audience, so please keep your comments hypothetical and not personally identifiable, so we're not violating anybody's privacy. Of course, if you do have student-specific questions, you are welcome to reach out to us offline, and we're happy to provide advice that way. Without further ado, I am going to turn it over to Brittany first to talk a little bit about Senate Bill 3606. Like I said, after that, we'll turn it over to Kristen to talk about the new ISBE guidance on student placement and specifically special education student placement. Then I will wrap us up with some reminders and tips for the school year relative to IEPs and special education placement. And then we'll save some time at the end for questions, but as I said, we do want to answer your questions throughout, so please feel free to use that Q&A feature and we'll monitor throughout so we can sprinkle questions as we go through the day today. So Brittany, why don't you tell us a little bit about Senate Bill 3606?
Thank you, Caitlin. I'm happy to be here. We are going to begin today's webinar, as Caitlin mentioned, with discussion of Senate Bill 3606, which was recently signed into law and forms the basis of today's webinar on special education placement legal updates. As you may be aware, this bill has been in the works for many years. On May 23rd, a few months ago, Senate Bill 3606 passed both houses and was signed into law by Governor Pritzker. So on July 1st, 2024, when it was signed into law, it became Public Act 103-0644. It's effective immediately, which means that beginning on July 1st, 2024, it was effective and continues to be effective moving forward. It amends the Children with Disabilities article of the Illinois School Code, specifically to provide for expanded state reimbursement opportunities to ensure that all children with disabilities receive the support and resources that they need. More specifically, the Act addresses special education placement and also implicates funding. So we're going to go a little bit into the definitions here. So pursuant to the new language, the definition of special education facilities and services now includes private special schools and separate public special education day schools. These are two additional types of special education facilities and services that were not previously included in the article of this school code. Therefore, keep in mind that the addition of these provisions offers a more expansive state reimbursement opportunity. Continuing with the changes that were impacted by the signing of this bill, the definition of separate public special education day school has been provided. So how is a separate public special education day school defined under this newly imposed act? Well, the statutory text says that a separate public special education day school includes separate special education programs or facilities that are established by a school district, public school, regional office of education, or special education cooperative exclusively to meet the needs of special education students who cannot be educated in the general school environment, and that also provides services comparable to a private special education school. This is the new language that has been added to this section, this article of the school code. So this does impact reimbursement. So how does this impact school district reimbursement for these special education placements? The Act addresses tuition payment adjustments for children placed in these separate public special education day schools, and it actually closes a loophole that neglected to provide for reimbursements for school districts who placed high-need special education students in separate public special education programs. So in terms of reimbursement, school districts will now be reimbursed for separate public special education day schools in the same manner as they are reimbursed for private special education schools and private residential facilities. This means that school districts will be provided with the same level of funding from the state, regardless of whether the student is recommended for a public or a private school special education program, which is really important to note here with this expanded definition, and also considering how that reimbursement is impacted. ISBE has provided guidance, but Caitlin, if you want to add any more insight on this, feel free to do so before handing it over to Kristen.
Yeah, thanks, Brittany. I know we have some IAASE members with us today and representatives. IAASE was really instrumental in this legislation and getting it through. This is something that, as Brittany said, kind of was in the works for many years, and it took a long time to get off the ground, and it's finally here. And this really allows school districts to utilize special education cooperative placements in a way that perhaps they could use them before, but they didn't have the ability to get the reimbursement that they were able to get for private special education facilities. So when you're looking at special education placements, the cooperative placements are now more perhaps available than they were before because they're less cost prohibitive, because you are going to have the same reimbursement available that you would for a private special education facility. Kristen, do you want to talk about the ISBE guidance that was released this summer on placement?
Sure, will do. Hi, everyone. My name's Kristen. I'm an associate attorney here at Franzik, as Caitlin mentioned. I'm going to talk to you today briefly about the ISBE guidance that was released this summer on residential placements. Now, this guidance document, some of you probably have already viewed it. It's about 40 pages long, and this is only a 30-minute webinar, so we're just going to talk about a couple portions of the guidance today, but if we don't get to a certain portion you have a question on, and we don't get to your question at the end of this webinar, feel free to reach out to one of us at the end of the webinar, and we're happy to help. In general, this guidance document is an FAQ, so it answers frequently asked questions related to residential placement of both general education students and special education students. It also answers questions about students who are put in residential placements by state agencies, students who are in the care of DCFS, or students that are homeless. So this really does cover a broad swath of students, and it's not limited to just special education students. So it's a very good resource. This largely is a review of previously released guidance, but it's all compiled into one document. So it is a good source of information. Now, as a reminder, before we delve a little bit more into some of the portions of the ISBE guidance, although consideration should be given to this guidance, hearing officers and courts are not legally required to follow this guidance. So school districts should still exercise independent judgment on making decisions about residential placement. So here are some reminders on placement basics. As I said previously, this is a review of statutes that were already in place and guidance that was already out, just compiled into one place. So it is good for reminders on the placement basics, including for residential placement. In this document, ISBE does advise that school districts should only place a special education student into a residential facility if it is the least restrictive environment for the student based on that student's needs as determined by the student's IEP team. This isn't news to anyone, but I just do want to emphasize it because that least restrictive environment is super important. A common situation that we see recently, there are some parents who want their students in a residential placement, but the IEP team does not think residential placement is the LRE. Parents will then unilaterally place their students in a residential facility because the IEP team did not choose that as the LRE. The ISBE guidance does contain an important reminder for this kind of situation. Districts are not responsible for paying for special education students who are unilaterally enrolled in a residential placement so long as the school district offered the student a free, appropriate public education. As such, showing the district provided an IEP that is robust and provides a FAPE is critical, especially down the line if there is a dispute about placement. So this guidance also addresses residential placements in non-approved facilities. It confirms that in order for a school district to receive reimbursement, the district must receive either emergency and student-specific approval from ISBE or placement ordered by a due process hearing officer contracted by ISBE. As such, school districts that move forward with placement at non-approved facilities prior to receiving reimbursement approval from ISBE or who are not making that placement based on a order from a due process hearing officer, they do so at their own financial risk that they may be bearing the burden financially of that placement. Accordingly, school districts who also enter into settlement agreements with parents to place a student in a facility not approved by ISBE cannot receive reimbursement for such a placement if it's not approved. So that's just something to keep in mind because I know as school districts and parents are, trying to find that middle ground and decide on a placement for a student, it is important to keep these in the back of your head so that you are aware of the repercussions of the placement decisions you're making and the financial burdens on the school district. The ISBE guidance also provides an important reminder on the process for seeking approval from ISBE for non-approved facilities. In order to receive that emergency and student-specific approval for a non-approved facility, one of the requirements is that the school district shows ISBE that it made a good faith effort to place the student in an approved facility, but approved facilities either did not accept the student or did not have the availability for the student or both. This is a really critical piece. And the guidance has a very good warning that school districts should be keeping in mind. The guidance warns that a parent refusing to sign releases for applications to ISBE approved facilities or generally refusing to place a student in a residential facility does not meet that standard we just talked about. It really does need to show that the approved facilities either did not accept the student or did not have availability for the student. That parent refusal does not meet that standard. So that is something to kind of keep in mind before you take further steps to seek that student-specific approval from ISBE. And another reminder that the guidance mentions, and that kind of, I'm sure we're pretty much used to it now, but it was somewhat of a recent amendment to the law a couple years ago. The Illinois law, as you all know, now provides that special education students can continue to receive educational services under state law through the end of the school year during which the student turns 22 years old. But IDEA funding ceases for the student after they turn 22 years old. So this guidance does accordingly state that school districts and ISBE may only expend IDEA Part B funds to residentially place students under the age of 22. This is something to keep in mind, again, just kind of towards that funding piece when we are deciding and considering residential placement for students. So I'm just going to turn it back over to Caitlin for some reminders and tips, and then we'll take any questions you guys may have for us.
So generally speaking, and these reminders are not unique or anything new as a result of the new Senate bill or the new ISBE guidance, but we want to really make sure we are thinking carefully before making any decision to place a student in a therapeutic day school or in a residential placement to make sure it is what the student needs and it is truly the least restrictive environment for the student. We don't want to agree to a more restrictive placement if it is just to appease the parents. Certainly, there are students who do require more restrictive placements, and in those cases, we absolutely want to place the student in the placement that they need to receive a free appropriate public education. But on the other hand, I have been involved in far too many cases where the parent wants a placement for whatever reason. It's closer to their work, they like it better, any number of reasons. We agree to it because we've just been sitting at the table for far too darn long, or we're tired of hearing about it, or we don't want to fight the fight. And then we get to that placement and it turns out the parent doesn't like the placement, or that placement can't provide the services that we thought it could, or hey, it turns out they're actually not approved. And the road to you know where is paved with good intentions. So we need to really, really think about what we are agreeing to before we agree to it. If a student is residentially placed, really try and do your best to get eyes on that student. Now, of course, there are times where that is not always possible. I know a lot of our students are placed in states out west where it's not that easy to get in a car and just drive and go see them, or hop on a plane and go see them. But to the extent it's possible, certainly if they're in the state, really try to go get eyes on the student, get eyes on the facility, try and get a handle on what's really going on there. That will pay dividends when you are in your IEP meeting, and in the future, if you have a request to place a student there, or you're thinking about potential placements for another student, you will be able to speak about what that facility can and cannot provide knowledgeably, in a way that you just can't by meeting with them on Zoom or looking at their website. And if we are changing a student's placement to or from a residential placement or a therapeutic day placement, really make sure we're documenting the reasons for that change in the additional notes. The additional notes are your best friend. Anyone who has heard me speak in our, writing legally defensible IEPs presentation or anything like that knows that I love the additional notes. It's the first place I turn in any IEP. When we have so many pages of the IEP and the goals section, we have a lot of space there to write. And then we get to our placement page and it's really just checking boxes. But there's not a lot of space there for us to really explain why did we choose this placement over that placement. Use the notes for that purpose. Why did we choose a therapeutic day placement? Why did we choose a residential placement? Or why not? Especially if there is a request for a specific placement and we are denying that request, we really need to go into why is the parent making the request and why does the school team believe that request is or is not appropriate? And what are the reasons? Because if we are going to receive a due process complaint, I want to know really what the discussion was at the table, what the parties' positions were, and what the consensus of the IEP team was. Where did we land? With that, I want to turn to some of your questions. One question we received, and I did answer it in the chat, but I don't know if anybody saw it, so I want to go back over it, it was about Senate Bill 3606, and I'm sorry I'm not looking at the screen. I have a separate screen up that has the questions on it. It's this Senate Bill 3606 covers public programs and special schools. We originally thought it was just going to be public day schools. Senate Bill 3606 defines special education facilities and services as private special schools and separate public special education day schools. So I believe that answers your question and that it covers both. We also received 2 questions about how to ask ISBE if one of your district schools would be a public special education day school. I cannot tell you the name of what specific person to contact at ISBE. I do know we have some ISBE reps on the line, so maybe they do. But I would start with the special education department at ISBE. And just make a call to say who can I best talk to about making this determination. My sense is probably a self-contained program would not be a separate therapeutic day school, but if you have a separate school that your district operates, it may be considered one, and there should be someone at ISBE that you could potentially talk to about that. We also received a question about if a student is placed in a residential program by a state agency, whether the school district is still responsible for their education services and the costs of those educational services. And that is addressed in the ISBE guidance. It's I believe it's question G4. I have the ISBE guidance up on my phone, because I want to maximize how many screens I can have in front of me at one time. I believe it's question G4. I'm sorry, it's G2 and G4. If the student is eligible for special education services, so I'm assuming that you're asking about an already eligible student, if they are placed by a state agency or a court, this is section G, then the school district is responsible. Now, it gets into some complicated areas when we have a student who either is not already eligible or there's a dispute over that student's residency. So which district of residence would be responsible? Or if they are placed in a non-approved facility. Then we get into some more complicated questions, and those are all addressed in the ISBE guidance. But you can look at section G of that ISBE guidance, and it addresses a lot of the different intricacies there. Our next question is, if a parent is consistently refusing placement at an ISBE approved facility that is willing to accept the student, what options does the district have? And if the parent is insistent on a non-approved placement, and this is a reason, what should the next steps be? I think that's something that a district would probably want to discuss with their independent legal counsel and probably problem solve on a case-by-case basis. The district's obligation is to provide a free, appropriate public education. And in that case, if the district has offered a free, appropriate public education at an ISBE approved facility, it has met its obligation. With that said, if the parent is refusing to send the student is not able to access their free, appropriate public education. So I would say that's going to be one we probably need to address on a case-by-case basis so that we can individually problem solve how are we going to get this student back in school. And I can think of a couple of ways we would want to address that with the parent, but we can't provide legal advice on a webinar. And I would want to know some of the specific circumstances and how many schools we've applied to, what specific services each school can provide, what it is about the non-approved facility that the parent likes. So I'd want to know more case specifics there. If ISBE approves a residential placement, is funding for both residential and educational costs equal for both ISBE approved and non-approved facilities? I don't, each facility, even ISBE approved facilities, has its own rate that's established by the Illinois Purchase Care Review Board. So it's not, even all of the facilities on the ISBE approved list are not funded at the exact same per diem rate. They're funded at a rate set by the Purchase Care Review Board. So not necessarily, it's not like they each get a set flat rate of $100 a day. Any other questions before we wrap up? Don't see any coming in. And we stayed within our time frame, which is extremely unusual for me. Well, we will let you all go then, because I know it is the first week of school and you all have students to get back to, but thank you very much for joining us. Please stay tuned for more webinars to come during the 2024-25 school year. We really appreciate your time and everything you do for students. And as always, if you have any suggestions for webinar topics, we are all ears. See everybody soon.